What's up, everybody? Welcome back to another episode of The Lawyer You Know. And today we're going to be taking a look back at the Brian Kohberger case because so much has come out about it. We've been doing some videos here and there. Some of you guys are sending me some of the documents. I really encourage you to continue to do so I know which one specifically you're talking about or you have questions about. But this one was shocking to me. When I read it, I was like, whoa. And this just continues to let me know that there's so much about this case we don't know. We're going to be surprised throughout this trial. And maybe some of it is bad for Brian Kohberger. Maybe some of it is good for Brian Kohberger. From my perspective, I just know we don't have all the information yet. And the affidavit that has been filed by Brian Kohberger and his team from their expert with I can't even explain how much experience and expertise this guy has. For him to come out and say what he said about the prosecutors in Brian Kohberger's case shocked me. So we're going to take a look at that affidavit today and see if this is an indication of a bigger picture and bigger argument we could see coming for Brian Kohberger in this trial. So this was filed on March 26th, and this is the notice of filing affidavit in support of the defendant's objection to the state's motion in limine regarding the AT&T timing advance records. And what's going to be important about this is what he has to say about the process and procedures. We're going to read through like what kind of an expert this guy is. First off, it's Cy Ray. We've already heard about him and talked about him before, but in case you haven't, we're going to get a little bit of his background here. But the interesting part is there are pieces of evidence throughout this case that the defense has said it's impossible for it to work like this, or they must have gotten more, or they couldn't have done it that way. And we know somebody has come before the court and told them it was not done the right way. And some shocking things have come out potentially about how this investigation has been done and the problems with it. Now, recently, we've also had some more bad facts for Brian Kohberger come out, whether it has to do with an Amazon order or DNA or what he bought, as far as the face covering potentially that was black, that was maybe seen by a roommate and maybe bushy eyebrows and maybe a picture of his hand with some injuries on it. So we'll see, right? Because both sides are building their cases. And a lot of the bad stuff that has come out and you guys had questions about, we talked about, but this is also something you had questions about that may be bad for the prosecution. And to me, I would hate it if this was in fact true. And I am inclined to believe it as true based on this guy's resume and the fact that he was willing to swear to it under oath in this affidavit. So let's take a read. Comes out Brian Kohberger buying through his attorney of record and hereby files the accompanying affidavit of Cy Ray in support of their objection to the state's motion in limine regarding the AT&T timing advance records filed with the court on March 17, 25. This affidavit is filed pursuant to the court's March 18th order denying the witness testimony at the April 9th hearing. So here we go. I am an adult over the age of 18, personal knowledge of the facts in this affidavit. I've been working in the field of call detail record analysis for over 25 years. I became a certified police officer in the state of Arizona in 1996. I worked with my first set of AT&T records in 97. I spent nearly 20 years in law enforcement in the primary role of a detective. I have worked hundreds of death investigations and consulted on over 1,000 homicide cases in my career. In my role as a detective, I gained extensive experience utilizing call detail records and exploiting cellular networks for investigative related purposes. In 2014, I retired from law enforcement and started a business called ZX that created software for law enforcement to map and analyze call detail records. As part of that business, we maintained software that supported every known call detail record provided to law enforcement in the United States. To date, the system has analyzed over 3 billion, that's with a B, calls from call detail records provided by cellular phone companies in the United States. In 21, LexisNexis purchased ZX. Congratulations to you, sir. And to date is still using and selling the software I created. As a result of this experience, I have worked directly with engineers at the cellular phone companies for over 2 decades and am intimately familiar with the type of data they maintain in the normal course of business and provide to law enforcement through a legal demand process. I mean, think about this for a resume for a defense expert. In addition to my law enforcement experience, I have instructed classes on utilizing cellular records in criminal investigations for nearly 20 years. I have had over 30,000 law enforcement officers attend these courses and or presentations on this subject matter. In 2014, I created the first geolocation cellular investigation subject matter expert course in this field, offered to state and local law enforcement officers. As a result of this work, I have established well-known and used best practices within the discipline of call detail record analysis. Over 1,000 law enforcement agencies have attended my courses on the subject matter of cellular record analysis, to include FBI, ATF, U.S. Marshals, DEA, and DHS. You may have heard of them, right? Through my work in this discipline, I am regularly consulted by the prosecution on investigations around the world. As a recognized subject matter expert in this field, I have testified on the matter more than 100 times throughout the United States in both federal and state courts. Apart from this case, every single time, not 50%, not 60%, not 75%, every time he has testified. I'm trying to find my place. Apart from this case, all my testimony in this field has been on behalf of the prosecution. That was a dramatic pause, but it wasn't intentional. It is only in rare cases and circumstances I have ever considered working on the side of the defense. So you may say, how's that possible? Well, maybe he's worked on the side of the defense before, but he said every single one of his testimonies, all of his testifying has been done for the prosecution. So maybe he's consulted with the defense or talked to a defense expert or defense lawyer. But if he testifies in this case, it would potentially be the first time he's ever testified for the defense, which matters when it comes to bias. He isn't some hired gun. He isn't some shill that just says whatever you want him to say. I have worked extensively with timing advanced data from the cellular phone network providers over the past 15 years. I have testified to the use of timing advanced data numerous times. I have created and taught hundreds of classes on this subject matter to law enforcement. I am extremely familiar with the type of timing advanced records available from U.S. cellular providers, their retention periods, and the legal process to obtain those records. Timing advance. Okay, now we're going to talk about timing advance. Timing advance records are maintained by cellular network providers that provide a time measurement. This time measurement refers to the amount of time it takes a radio signal to travel from a cell site to a mobile device and back to the cell site. Given this signal travels at a known constant speed of light, it is possible to use the measurement to determine the distance the mobile device is from a known cell site. And you can start to understand why they're using it. He's an expert. He's doing a good job of helping even somebody like me, who's not an expert or understanding these fields, understand it in a simplistic way. That's important for an expert. When multiple cell sites record time advanced data in short periods of time, it is possible to use triliteration to determine the location of a mobile device. The use of timing advanced data in this matter is one of the most accurate ways for law enforcement to locate a mobile device. Given these records are available in a historical context, it is possible to conduct an analysis of timing advanced data to pinpoint historical locations of a mobile device at a given date and time. It is also possible to determine routes of travel, stagnation, and when a mobile device is powered on and off. So you can start to understand how it might be used in this case. As a result of its accuracy, requesting timing advanced data has become a standard practice for all law enforcement in the United States and is regularly requested through legal process relating to a criminal investigation. And frankly, he has helped with that. He has trained people on that, how to get it, how to use it, how to testify about it. And he's testified about it himself. So he knows about it. Gosh, my ear is like still not, I feel like it's still not popped from the airplane days ago. In advance of 2021, I was approached by an FBI agent to assist in analyzing a type of record set identified as AT&T Timing Advance Report. And it was the first time I was made aware of this type of data from AT&T back in 2021. Upon request, I can provide the date, time, and location and FBI agent I assisted with the record set. So not this case, but this was his first experience. As of the year 2021, AT&T had not officially released a timing advance report to law enforcement. Therefore, the ZX software program did not yet support AT&T timing advance record. As a result of this interaction with the FBI, I obtained a copy of the timing advance report from the special agent and forwarded it to our software engineers to write code within ZX system to support future uploads of this timing advance report format. The people that do this type of stuff sound so smart, right? I just forwarded it to my guy to write some code, and then we fit it in there at ZX. The next day, I was informed by the special agent the AT&T timing advance report was not supposed to be released viewed outside the FBI, and that the individual requested I return the report and not have any software developed to support the data they had shown to me. I did return the report. However, due to the interaction explained here, there is a paper trail documenting the facts of this interaction. I have firsthand knowledge that AT&T was providing the FBI with timing advance reports prior to August of 2021. So now is when you start to get a little bit of a side eye. It's like something sounds off here. AT&T legal demands. During my careers, working with call detail records from every cellular provider in the United States, I've been involved with thousands of cases in which call detail records are obtained from these companies. Leading the way in the establishment of best practices within this field of investigation, I wrote and provided custom search warrants for every provider and distributed them to thousands of law enforcement officers in the United States, assisting them in the legal process of obtaining the vast and ever-growing amount of data sets offered by cellular providers. I mean, it's just, growing. What our cell phones have in them is crazy. I have worked with the AT&T Global Legal Demand Center for over 15 years. I have firsthand knowledge that the AT&T Global Legal Demand Center is one way, in bold and italics, not the only way for law enforcement to obtain call detail records from AT&T. That's important. I have firsthand knowledge that there is another way, in bold and italics, to obtain call detail records from AT&T without going through GLDC. Over the course of many years, AT&T has had several different programs in partnership with federal law enforcement, primarily the FBI, that allowed for call detail records to be disseminated to the FBI without going through the standard GLDC process. The first AT&T timing report I was presented and had a chance to review and become familiar with in August of 21 was obtained from AT&T through one of these programs, not through GLDC. So he himself has gotten AT&T timing reports through other means than the GLDC. I have been involved in numerous investigations where AT&T call detail records were obtained through these AT&T programs outside GLDC. I have firsthand knowledge and experience in working with individuals at AT&T associated with these other programs. And here's my point. I don't think this guy would lie about this. And I don't think that he would swear under oath if he was going to lie about this. This is his career, reputation on the line. It doesn't make any sense for him to lie, which is why I tend to believe what he's saying here. One such individual is Boyd Jackson. Mr. Jackson is a program director at AT&T who manages many of the programs I'm referencing. Mr. Jackson is the primary contact for the FBI when requesting records outside of the standard GLDC process. You think defendants and defense attorneys can get it out in these processes too? You think the FBI makes it as easy for them to order these things if they want it on a witness or if they want it on their own client? It's a rhetorical question. GLDC disseminating timing advance reports. And frankly, this guy who only works with prosecutors except on certain occasions, it would be nice to have him work for the defense more so that we can get information. GLDC disseminating timing advance reports. The state is correct in their claim that AT&T GLDC did not provide law enforcement with AT&T time advance reports until May of 23. That's what the state said. As a matter of fact, in May of 23, the working group known as GLDC had only begun their storage of timing advance records. The first official release of AT&T timing advance data was not provided to law enforcement until June 15, 2023 by GLDC. In 2022, the FBI obtained AT&T time advance records from another source outside of the GLDC. AT&T timing advance records in the state's possession. During this investigation, the law enforcement obtained the following AT&T time advance data. 2 of the victims had AT&T phones. Law enforcement obtained AT&T timing data on both of their phones. Law enforcement developed an early investigative lead in this case. That person had an AT&T phone at the time of the crime. Law enforcement obtained his AT&T time advance data. Law enforcement also requested a tower dump consisting of AT&T timing advance data. This request involved AT&T providing all of the connections between 2 specific cell sites in Moscow during a 2-hour period. The data produced was AT&T timing advance data. In all, there were over 3,800 AT&T mobile phones identified in the timing advance tower dump data. The AT&T timing advance data was obtained by the FBI using an internal source at AT&T, Mr. Boyd Jackson, who is not associated with the GLDC working group. GLDC was not used to obtain this data. A forensic examination of the AT&T timing advance record in the state's possession show Mr. Jackson's association with the reports. There is work product in the state's possession created by the FBI showing the AT&T time advance data was not only obtained but regularly referenced and used in the course of this investigation. Its existence is well known to the investigators and prosecutors. Chain of custody. The state has provided a certificate of authenticity to the defense in relation to the timing advance records described above. The COA, the Certificate of Authority, was created on April 24 and issued by the director of the GLDC, Stephen Gordon. I have previously worked with and I am familiar with Mr. Gordon. The COA specifically states, I am qualified to authenticate the records attached hereto because I'm familiar with how the records were created, managed, stored, and retrieved. I have personal knowledge that in the event Mr. Gordon was required to testify, he would clarify that prior to May of 23, neither he nor AT&T GLDC working group was involved with AT&T timing advance records. Additionally, there is forensic evidence. This is why you want to get all the metadata and background stuff and all the notes and reports so that these experts can look at them, because we lawyers or even we normal people that are not experts might not know what it means. So to just say, you don't need the metadata, we're just going to have a cop testify to it, we'll trust the cop. This is just evidence that shouldn't be good enough in today's day and age when this evidence and footprint and, data here and there that you can pull from exists. And we can prove it with experts that know how this stuff works. And I use words like this stuff works to show that we don't get it the same way they do. And we, lawyers/judges, are the ones put in position to make these decisions. And so when people are just destroying things or overwriting things or saving things a certain way, it's a problem. And it shouldn't just be brushed under the rug. And if we don't force them to stop, meaning law enforcement, and do things the right way, then they're not gonna. Additionally, there's forensic evidence obtained within the records that indicate that they were not produced by AT&T GLDC, nor were they produced in the year of 2024. In retrieving this data, I contacted and communicated with Mr. Gordon to clarify the chain of custody related to these records. Gordon and an AT&T legal representative informed me that Mr. Gordon would not be the individual to certify these records if requested to do so, despite issuing the COA. Isn't that funny? In my review of this information, there is evidence to suggest the chain of custody involving these records and COA were produced well outside of AT&T's normal practice. How about that? Does it mean Brian Kohberger is innocent? No. But is this a problem? Yes. Is this affidavit a problem? If everything in it is true? Yes. There is missing information and data associated with this request. Also a problem. Discovery violation, potentially Brady violation. And if you think Kohberger's guilty, you should be extra mad at this. Because if they really do violate his rights in this way and this case gets thrown out, what do you think about that? That's why just law enforcement, all witnesses, all lawyers need to do things by the book and within the rules in order that we can get a fair and just result in every trial. The prosecutor's prior claims that AT&T timing advance data, and obviously if you think Kohberger's innocent and didn't commit these crimes and is being framed or something is happening, they just got the wrong guy, well, this should also anger you if, in fact, things are not being done above board and whatever is being done is not being turned over properly to the defense. The prosecution's prior claims that AT&T timing advance data did not exist in 2022 further complicates the issue. It is my expert opinion that any testimony proffered on behalf of the FBI or AT&T on this matter would clearly reveal these issues. Evidence in direct contradiction of the state's motion. That's not a good heading for the state. In my review of this investigation, I have read numerous emails sent and received by law enforcement pertaining to their investigation. One such email, dated 11/15/22, was sent to Prosecutor Ashley Jennings at her Latah County government email address. This email is from Moscow Detective Lawrence Mowry. The email is informing Ms. Jennings of Detective Mowry's recent contact with FBI Special Agent Balance. Special Agent Balance informed Detective Mowry that AT&T can provide timing advance data and to make sure it is listed in the search warrant. Detective Mowry is specifically asking Prosecutor Jennings to make sure AT&T timing data is listed in the warrant prior to the report ever being distributed by the working group known as GLDC. Ms. Jennings did respond to Detective Mowry's email inquiring of the specific verbiage needed to obtain the AT&T timing advance. The email is abundantly clear evidence that Ms. Jennings was not only aware of the existence of the AT&T timing advance in 2022, but also shows her intention to obtain it through legal process from AT&T. This email communication with prosecutor Ashley Jennings is the same prosecutor Ashley Jennings who filed the current and contradictory motion, stating AT&T did not produce timing advance records in 22. There is clear and convincing evidence that not only was the FBI able to obtain AT&T timing advance records in 22, but they did so with the knowledge of the prosecutors involved in this case. So why misrepresent that? What's the importance there? What are they trying to hide? Was it an oversight? Was it negligence? Was it an accident? Some people have some explaining to do. Missing AT&T timing advance. In my review of this investigation, based on my training and experience, it is incredibly unusual that the defendant's AT&T timing advance records were not obtained by the FBI. The FBI demonstrated their ability to obtain the AT&T timing advance record in November of 22 by obtaining AT&T timing advance records on over 3,800 mobile devices, none of them being the defendant's. When it comes to location data from AT&T timing advance can be some of the most accurate data available. Additionally, it contains connections to the network other than the typical voice, text, or data connections. By the way, I'll let you guess what could be in there and why either they didn't get it, or if they did get it, they didn't turn it over. Why the shade? Why the sus actions? This allows law enforcement to not only see more data, but more accurate data. Anytime a defendant's locations are in question, a timing advance report would be asked for as a standard operating procedure. Moscow Police Department, by way of the FBI, and with the knowledge of prosecutors, demonstrated their awareness of this standard procedure when they obtained AT&T timing advance data on over 3,800 mobile devices. When detectives and prosecutors requested and served 2 different search warrants to AT&T on the defendant's AT&T account, they requested the exact same timing advance data they previously did when they obtained timing advance data from AT&T on over 3,800 mobile devices. They also maintained the same process in utilizing the FBI to serve the legal demands on AT&T. There is no difference in the verbiage, legal process, or individuals that produced AT&T timing advance data on 3,800 mobile devices and the request for the defendant's AT&T timing data that allegedly yielded nothing. Additionally, on December 23rd, 22, the FBI sent communication directly to AT&T, specifically detailing their request for the defendant's AT&T timing advance records. There is no reason to believe AT&T would not respond to this request. It is my expert opinion that AT&T timing advance data did exist for the defendant's AT&T mobile device in 22, and it was requested from AT&T by the investigators involved in this case. The investigators previously demonstrated their ability to obtain AT&T timing advance data in 22. Failure to produce the defendant's AT&T timing advance data is either a gross deviation from standard practice or intentionally withheld from release and discovery. He's like, you definitely asked for it because you knew how to ask for it, and you definitely got it because you got 3,800 other ones that you asked for the same exact way. Whew. Conclusion. It is my expert opinion in reviewing all the evidence that has been disclosed to the state that AT&T timing advance data was available on the defendant's phone in 2022. There is overwhelming evidence to show that showing the state obtaining and using AT&T timing advance records in the course of their investigation in 22 on over 3,800 AT&T mobile devices other than the defendants. There is no doubt the author of this current motion, prosecutor Ashley Jennings, knew or should have known AT&T timing advance data did exist in 22. She was directly involved in the legal process obtaining it and was aware of work product created from it to further the investigation. The current motion is a deliberate misrepresentation to the court to further conceal false statements used to obtain probable cause against the defendant and conceal exculpatory evidence from discovery. This right here, folks, my highlighter is not working. Starting right here, this is what gets cases dismissed. If you deliberately misrepresent something as a prosecutor to the court and you conceal false statements and you use those false statements to obtain probable cause and you conceal exculpatory evidence from discovery, that's case dismissed. That's crazy if that's what's happening. That's why I said if this motion is true, prosecutors could have some major problems. Now, let's see how the prosecutors respond. Let's see what they say. Let's hope they don't just say, "Oh, they copy and pasted it on their computer somewhere else, so we lost the metadata," right? Hopefully, there's some kind of explanation for this. Hopefully, he misunderstood something, because it would be very bad for prosecutors to handle a case like this. It would be horrible. They should lose their license if they're deliberately misrepresenting things and concealing false statements and using that to get probable cause and concealing exculpatory evidence from discovery. You should not be a lawyer, let alone a prosecutor, if you're doing that. And here we go. He's going to double and triple down. I am prepared to provide witness testimony and relevant exhibits that support all my opinions contained in this affidavit, including that last one we just read. It is my belief this evidence is beyond clear and convincing and will be supported by any competent expert in this field who reviews all the data. This is not a battle of the experts. The evidence supporting the opinions in this affidavit is overwhelming. Will the defense call more people? Will the state call some people to rebut this and say, no, you're wrong? In my nearly 30 years, this is his last comment here. In my nearly 30 years of working with and for prosecutors all over the United States, I have never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. And you remember, the defense in this case has been pounding the table. We know there's more, Judge. Our experts are telling me there's more. They're saying it doesn't exist. They're not turning it over. But we know, based on what we have, that there are things they are not turning over. And we were like, what are they talking about? It's all so vague. Is this hyperbole? What are they talking about? I think we're starting to find out. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in possession of the state and the defense. It's a little challenge to the judge. It's like, Judge, any competent expert would get this. Judge, they think you are incapable of plainly looking at the evidence in front of you. It rises to a level beyond a simple miscommunication or oversight and is clear and intentional misrepresentation in the hopes to conceal a much larger issue. Whoa. I respectfully request the court give this affidavit the due attention it deserves and explore these issues further. Signed, Cy Ray, prosecution witness for 30 years, former cop, wrote the book on this evidence, has only ever testified for the prosecution. This might be the first time he ever testifies for the defense. Very rarely even considers ever working with the defense. That guy, that Cy Ray, says this was the worst version he's ever seen of a prosecutor deliberately attempting to mislead the court on evidence in plain sight. This is a prosecutor misrepresenting and concealing false statements to get probable cause, and then trying to conceal exculpatory evidence from discovery. If this was a court order, if this was a judicial finding, there would be no way that, this is too many double negatives, triple negatives I'm using. If this was a court order, if this was a judicial finding, it would absolutely end with this case and all charges are dismissed. That is the only way you finish something like this if this is found to be true. The judge has a tough call to make now. A tough decision in front of him. Is Cy Ray just flat out wrong? Is Cy Ray lying? Or if he is correct and telling the truth and he's right, you got to deal with it, and you better deal with it. I don't know, right? I haven't seen the evidence. I can't make the call. But that's a pretty good resume. It's a pretty good starting point if you're the defense, calling out the prosecutors here in this case. I'm concerned. We had a lot of this in the beginning. It sounded really bad. Then a lot of stuff was sealed. Then some really bad facts for Brian Kohberger starts trickling out. But now we're getting back to what happened in this investigation. Is there shade? Let's shine a light in the darkness here to see what actually happened. And if they broke the rules, they need to be held accountable, regardless of the cost. That's the way our justice system is set up. That's the way our Constitution is written. That's the way you should want your country. Because if they're going to railroad Brian Kohberger, they're probably going to railroad you. And we need to be careful to protect against that. Regardless of what we think about the defendant. Any defendant. Whew. All right. That was an interesting one, folks. Thank you for sending it to me. And again, continue to send me documents that have these questions and have these just wild parts of them, because it never ceases to amaze me what happens in these cases. But I appreciate you joining me. Make sure you hit that like button if you have not already. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.